In the last mini-lecture, we looked at federalism and the Constitution, particularly the clauses dealing with Congress, full faith and credit, and privileges and immunities. In this mini-lecture, we will look further in the Presidency and the Supreme Court and other provisions of the Constitution. The President is the most national type officer, but the President is not elected directly by the whole people of the United States. The President is elected through what is called the Electoral College. In this system, each state has a number of electoral votes equal to the number of its representatives in the U.S. House, plus its 2 senators. For example, states with small populations such as Wyoming have 3 electoral votes. The biggest state, California, has 54 electoral votes. Altogether, there are 530 Electoral College votes. To win the presidency, a candidate needs 270 votes. In 48 states, the candidate who wins the most people's votes gets all that state's electoral votes. Thus, the winner in California gets 54 electoral votes. Maine and Nebraska, however, apportion their electoral votes among their U.S. House districts. The Electoral College has become controversial because in 2016, the candidate who won the Electoral College vote lost the people's vote. In 2016, Democrat Hillary Clinton got 66 million popular votes. Republican Donald Trump got only 63 million popular votes. But the way those votes were distributed among the states gave Trump 304 electoral votes to win the presidency. So critics say the Electoral College is undemocratic. It is, if one defines democracy as rule by 50% plus 1. However, the Electoral College and the entire federal system is structured in part to prevent such a pure democracy out of concern that would create a tyranny of the majority over the minority, especially of large urban states over less populated rural states. Of 59 presidential elections over more than 230 years, in only 5 did the winner lose the popular vote. The first was in 1824, when the House of Representatives chose the winner because no one got a majority of the electoral votes. The next 2 were in 1876 and 1888, when Republican candidates won while losing the popular vote. These outcomes, however, were due mostly to violent suppressions of black voters in the South who would have voted for the Republican candidates. It wasn't the Electoral College, but voter suppression that made those 2 elections undemocratic. Because of the 2000 and 2016 elections, however, many people want to abolish the Electoral College, but doing so requires an amendment to the U.S. Constitution, and there is not enough support for such an amendment. The third branch of government, the Supreme Court and lower federal courts, is embedded in the federal system in 4 ways. First, all justices and judges must be nominated by the President and approved by the Senate. The state's House, the House of Representatives, plays no role. Second, the jurisdiction of the federal courts is limited to cases involving the Constitution and federal law, international law, foreign states, the United States as a party, controversies between 2 or more states, and controversies between citizens of different states. State courts retain the broadest jurisdiction, such that even today, the federal courts hear less than 2% of all litigation in the United States. Third, federal district courts, which are the courts where federal cases start, operate entirely within state boundaries. No federal district court straddles 2 or more states. And fourth, in criminal cases, the trial of a defendant must be held in the state where the alleged crime was committed. A very important federalism clause in the Constitution is the Supremacy Clause. This clause provides that the Constitution, federal laws, and treaties are the supreme law of the land. Therefore, they override any conflicting state laws. This was another major change from the Articles of Confederation, which contain no such clause. However, let's be clear about the Supremacy Clause. This clause does not mean that the federal government is supreme over everything. It is supreme only within its constitutional sphere of authority. Outside of that sphere, state constitutions and state laws are the supreme law of the land. Amendments to the U.S. Constitution require the approval of 2/3 of both houses of Congress and ratification by 3/4 of the state legislatures or popularly elected conventions in 3/4 of the states. There is another route by which 2/3 of the state legislatures can petition for an amendment, but this route has never been used. Because the Constitution is difficult to amend, there are only 27 amendments. The first 10 amendments of 1791 are called the Bill of Rights. The 10th Amendment is the key federalism amendment because it reaffirms that all powers not delegated to the federal government by the states are reserved to the states or to the people. So it's important to note that the U.S. Constitution does not grant powers to the states because it is the states which previously possessed all powers that granted powers to the federal government. This is why the 10th Amendment says that all undelegated powers are reserved to the states or the people. Only 3 amendments have somewhat increased the powers of the federal government. The first is the 14th Amendment of 1868, which was adopted mainly to protect the rights of African Americans liberated from slavery by the Civil War. Among other things, this amendment states that, quote, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." Further, Congress is given authority to enforce this amendment against the states. This amendment has been the source of an enormous amount of litigation and legislation and a major basis for the Supreme Court in the 20th century to expand federal authority over the states with respect to human rights protection. The 16th Amendment of 1913 allows Congress to levy income taxes. These taxes became a major revenue source for the federal government and a tool for influencing the state through federal grants and aid, which we will discuss shortly. The 17th Amendment of 1913 required the direct election of senators by the people of each state and thus abolished the selection of senators by the state legislatures. Over time, this amendment resulted in some increase in federal power because it loosened senators' ties to their state governments. So we have summarized the major federalism dimensions of the U.S. Constitution. Because of the compound nature of this federal republic, the founders did not know what to call the government headquartered in Washington, D.C. For nearly a century, it was commonly called the general government. In 1835, the French observer Alexis de Tocqueville called it an incomplete national government. Today, it is commonly called the federal government. The U.S. Constitution is important for a number of reasons. It is the world's oldest written national constitution still in effect. The median lifespan of a national constitution around the world is only 19 years. The U.S. Constitution has lasted for more than 230 years. The U.S. Constitution also served as a model for many other constitutions around the world, both federal and non-federal. The U.S. Constitution also made democracy on a large scale possible for the first time in human history. Prior to 1789, geographically large political systems were empires, not democratic republics. Today, about 28 countries have some type of federal form of government, but together they account for 43% of the world's population and for 7 of the 8 territorially largest countries in the world.